thank you. Thanks so much for the warm welcome, Colin. And I'm sorry to have the PowerPoint up because then I can't see you, but I'll come back to you as soon as I finish the slides. This is a perfect audience to share this with, and I appreciate you all being here. Given that you're deep in the experience, many of you have taught, and so the book was really oriented to a mixed audience. They say you're not supposed to do that, but did really want to focus on practitioners and providers, as well as those who are teaching. So I'll quickly give an overview of what it is, a dispute system design, and then the framework that we developed to help all of us diagnose a situation and determine what kind of a system makes sense. I'll then splice in some online dispute resolution, and then Colin and Ethan and I are writing an article and really talking about the fourth party and AI in systems as a role. So you can tell me whether you want me to let you ask the question later or whether I can touch on it in my remarks. So system design is just one or more processes adopted to prevent, manage, or resolve a stream of disputes connected with a particular organization or institution. So it can range anywhere from the public arena, public and community justice for courts, and courts have really leapt in over the last 8 months. Claims facilities, Ken Feinberg, that many of you know of, has done so much work with Boston Marathon, with 9/11, with Las Vegas. There are wildfire claims facilities, floods, natural disasters like Katrina, and then there are just tort liability like asbestos or such, like the BP accident. And the reason I expand on the claims facility so much is I think this is somewhere where everyday people will encounter claims facilities. So whether you are asked personally to help conduct a claims facilities, design how the person that's liable or organization that's liable would be compensate those that have been harmed. And so you could be a member of the community that was harmed, and you could say, you know, we need a fair, transparent process. And I think this is an opportunity for many of us to serve in system design. Neighborhoods, restorative justice with the courts and privately, certainly in the commercial arena and employment arena, and internationally. I was up at 2 this morning to observe the UNCITRAL conversations and diagnosis of coming up with a system for dealing with investor-state disputes. And so they're trying to think what forms of ADR make sense and who says and what are the options. So that gives you an array of all the systems that might come out. I had a student who took the class, and probably within the year after he graduated, he emailed me and he said, "I'm doing system design." I said, "Oh, what are you doing?" And he said, "I'm working on a bankruptcy case, and my senior partner never heard of system design." And so I was able to make some suggestions on different kinds of processes that would fit different kinds of creditors. So I think it's around once you see you have the word and some concepts. So we came up with an analytic framework with 6 elements that we've been teaching, and it seems to cover most of the issues that come up with system development. First is goals. Second is stakeholders, the context and culture, the process options, the resources, and success and accountability. So that's the overview of the elements. I don't have a snappy acronym, but I just don't have a snappy acronym. We didn't come up with one. But the most important of these elements, I think, is goals. Because unless you're really clear about who you're trying to serve, what problems you're trying to solve, You can't assess the success at the end of the day. So it takes a lot of time. Seems obvious, but people often just jump in and think we're going to do something fair to help these people. And so thinking about what are you trying to accomplish? What kind of conflicts? Do you want all disputes to come to court or just family or small claims? So there are some really basic questions that are worth reviewing. Stakeholders, as we all are familiar, who cares? Who's affected by this system and its processes? What are their interests and how do they relate? And who has what power? Very often in system design, it is not a fresh de novo design, it's a redesign. So however status quo plays out, somebody likes it that way. So to try to redesign can sometimes be a real challenge. In tracking the power makes a difference. The context and culture, is this a crisis, an urgent matter, or is it a gradual development or redevelopment? And what is the culture of the industry, the people that are affected? The processes we know are many. So in our chapter on processes, I think we cover maybe 30 different kinds of processes, and you're familiar with them. And thinking about, is the process oriented to prevent? Is it a diagnostic function? Manage existing disputes or resolve them? And if there's more than one process, are they sequenced or linked in some obvious way? How does the more informal process connect to the court system in the formal processes? So really thinking about, what do we want our process to do? Who is it serving? And what are our choices and how will those fit? Resources is something that often isn't thought about till later in the game. And we just wanted to highlight that it's important to think about both the human and financial resources that are implicated by the processes you're putting in place. So even if you design a Cadillac system with 4 processes and ODR, but you have a bicycle budget, then that system is not going to function as it should and will be a disappointment and actually might leave people worse off than when they started. So really thinking about, do we have the training and the accreditation and the support that is necessary to deliver? And then at the end of the day, we should be thinking about, have we succeeded at our intention, our goals? How transparent is the system? Is it accountable to those who use it? The Pew Charitable Trust is taken on a $5 million evaluation of ODR systems. So this is an example where they are explicitly trying to determine some metrics for success and then trace what is happening in the US. So Ethan's early work on the fourth party, excuse me, and what is the role of technology? And I'm cribbing from some of the Collins slides, but right now you can see technology used for intake, diagnosis, case administration, and the beginning of algorithmic resolutions. Some of you may be familiar with the Wisconsin Supreme Court case, trying to assess whether it's fair, whether the IP owned privately is used to do use an algorithm to assess whether a defendant was likely to recommit, and whether the defendant has the right to know how that software was put together that was making a determination. The court in that case has decided it was just a suggestion that was made to the court, and therefore the defendant was not entitled to understand the algorithm that made the decision around his freedom. So I think a lot of the issues around regulating technology going forward is going to be a real challenge. Certainly in the future, today, there are all these options that technology can use. And looking forward is thinking, what can it do tomorrow? certainly for as lawyers, we appreciate the research function that technology can serve. Certainly case evaluation, things even like smart settle, trying to determine is there a zone of possible agreement and how might we assist the parties in getting there. Coaching, enforcement. Colin has developed administrative tribunals and with Modria and Tyler in thinking about how do we enforce certain decisions. There's a lot of work on document drafting and automated negotiation. So the issue that Colin and Ethan and I and Leah, who's been our co-author, are thinking about is where are all the places that automation might go? And might we have automation avatars and agents in the party role, in the third party role, and how does that all fit together and what are we comfortable with? And I think we in the room are one age and culture. Our children and grandchildren are probably going to have different expectations and capacities. So bringing in ODR as one of the possible process options in a system is really to use information and communication technology to help parties do all those things, prevent, manage, and resolve. So that can be anything from diagnosis through the processes, negotiation, direct party, or to a third party process like mediation, arbitration, or variations on those. So we have current examples that really illustrate how ODR has been effective and can be. E-commerce, where it started, where there was no alternative process because people in cross-border, low value, high volume situations are not going to be able to invest a lot and they can't go to court realistically. So coming up with a system was really called for. But I think there was a lot of resistance among us who do mediation saying, I think the person-to-person method is better and gets the relationship on the table and to create more imaginative and flexible outcomes. But now with COVID, I think we're experiencing this differently and seeing the array of times and places where the parties really would rather not see each other, or the transaction costs of seeing each other is more expensive than they're willing to bear. So the courts, administrative tribunals, and now even smart contracts in the blockchain, this is a fancy and sexy area. It is not very developed. There are only really prescribed disputes that really can function in this way at this time, but it's definitely on the go. The crowdsourcing that Modria did in the early days in India, where you just gather 100 random people and let them make a decision, and then the automation can coordinate that. That's grown, and now I'll show in a minute the application of this in more sophisticated disputes. The goals, so going back to our first framework element, is thinking about what do you want to accomplish. Now, this list is all pretty good. It's like mom and apple pie. Everyone wants it, all of it, but someone needs to make a decision about what's most important. Is it the efficiency? Is it access to justice? Is it transparency? Which of these goals are more important, and therefore that you need to have an ODR that functions in that particular way? So I think this is one of the issues that maybe we'll talk about is who decides what is fair, what is technically feasible, what goes to the provider, a third-party provider services in terms of their reputation. So I think the goals we can imagine and are very expansive, but it also is, we usually can't have it all unless you have a catalog budget. So that brings us to who decides in the world of system design. So we wanted to look at where the power and control is in terms of a particular system development, and looking at it at two levels. Who designs the system, and actually who designs the process for designing the system is probably more accurate, because whoever designs the system has the power over what it looks like and how many people were involved in that decision. Was it all the parties? Is it the parties plus the stakeholders? Is it just one party, like Kaiser designing its arbitration system for medical malpractice and deciding it's going to be arbitration? They've expanded and now added in mediation as well. But is it a one-party situation? Is it a third-party situation? Determining, you go to court and the court coordinator says, oh, you need to go to mediation first before you can come before my courtroom. So Utah has developed their court system, has a coherent set of rules. So because all of their counties are on the same set of rules, they were able to gather together with the leadership of Justice Hinojosa to develop a new ODR system. And they have done what is called a regulatory sandbox to develop new legal products and services. So that's all different ways that the system might be developed. And then on an individual case, a question is who gets to decide which process that person gets to use? Is it the disputant? Is it a third party making that decision? Or is it technology, which is entirely possible, that an algorithm will be put in place and you will go into the algorithmic system and it will determine or predict what your outcome is likely to be and therefore which process you may want to use. So this is way too many words to read, but I'm happy to share in the chat both the book flyer with the discount and also a paper that you might want to look at and that breaks this all out. But my intention was to show the array of ODR systems that are in play now and measure them against the 6 elements of the framework. So I'm comparing eBay, the court and tribunals, Nextdoor, social media, and Clearos, which is what I just talked about, is dealing with crowdsourcing and the decisions and their I don't know whether you would say the deciders are neutral. I think they're neutral, but they're biased because they have to pay to get into the crowdsource arbitration panel, and they get paid based on whether they are part of the majority decision. So if they guess the right decision, then they do well. If they don't, then they lose. So it's a really sophisticated system, and it's quite interesting to think about what are the goals and whose goals are we tracking and how is it playing out. So a number of ways just to compare what the ODR world is looking like. And then the last thing I want to touch on is the whole notion of ethical principles. So Colin just touched on at the opening on the different principles and standards that have been developed at NCTDR with Ethan and Leah, and then how that ICODR is trying to pick up how the application can be expanded to a lot of different contexts. So simple principles like competency and accreditation, the notion of fairness to whom? Is it timely? Is it efficient? Is it reasonable in cost? Do parties have access to counsel if needed? The neutrality of the process, the confidentiality, as well as the transparency. So there you have 2 principles that are in tension: the confidentiality and transparency of the process, and the both being addressed. And then party self-determination. Can parties decide which process, ODR or not, that is available to them for dealing with their particular disputes. Oh, okay, so that was a quick overview of
Fantastic.
some of the system design lens that maybe you can use for thinking about when, under what conditions, ODR can play a really important role, and how will that juxtapose with the other in-person processes that are available.
All right. Well, Jan, I'm so indebted to you for doing this webinar. I've actually decided to pay you with an acronym. So
Oh,
I came up with one. It's going to
okay.
be GASCAP, goals and stakeholders and context and processes. Yeah, that's GASCAP. You can make it GASCAP red, and then you include resources, evaluation, and designer. But GASCAP, there you go. That's my acronym for
Okay,
your
Colin,
system
and
design.
I thank you.
There you go.
Okay.
But no, from the beginning, I think the
Mhm.
people in dispute resolution who got ODR first were the dispute systems designers.
Yeah.
And I think the reason why is because when you have human-powered ADR processes, DSD is important. But when you have software-powered dispute resolution processes, DSD is essential, because
Mhm.
the code that you write, the software that you design, the intake process, the questions, you're essentially taking your systems design and you are enshrining it in code. And I think it
Yeah.
makes DSD very, very specific, because the task that we have as ODR systems designers, we have to actually make manifest in a way that face-to-face dispute systems design. You know, you can design something on paper and the parties may say, well, let's skip section 3. But when you write a computer program, you can't skip section 3. You have to go through it as it was coded by the developers. So that's why I think this is so important. So I'm eager to open it up and hear what everybody has to say, especially Ethan. You know, if you've got questions you want to surface. But one of the things that I love that you talk about in the book is power. And you talk about power over versus power with
Mhm.
others. You know, the big criticism of getting to yes, and the dispute resolution field more broadly, is that we're naive about power. And when you talk to dispute systems designers and mediators, we always talk about creating a level playing field. Oh, we
Mhm.
want to create a level playing field. But can we really ever create a level playing field? I mean,
Yeah.
there's almost no playing fields in society that are truly level. So
Mhm.
I wanted you to talk a little bit about, and I think this gets a lot to stakeholders, but it
Mhm.
also is, when you are an ODR software designer, you have power. Even if you are not going to be involved with any individual dispute, you have power. And so I want you to talk about the relationship between dispute systems design and power.
Okay. So I think one is the question, as you started with the level playing field, is can you level the playing field? I mean, is there a way? Because someone is going to have more resources, more information,
Right.
more something. And then should you? Because I think that's a real tension for those in a mediation role, is what's appropriate. You want it to be even, but how much do you put your finger on the scale? And so I think it comes up in ODR in terms of data, because so much of the technological uh, development around algorithms and predictive software is going to be based on data. So, what is the corpus of data on which you are designing a system?
Hmm.
So, going back to your question about power with and power over. So, power over is when someone gets to decide this is the only path to justice that is available to you or to your kind of dispute. So someone like a court is in the position of saying, this is your option, and I'll run the court like I run the court. Then power with is when you draw in not only the parties, but other stakeholders who would be running the system and say, what are we trying to accomplish? And power together is going to be more responsive to the needs of the user. So some of you may have heard of the design thinking and the design work that's done at Stanford. And a lot of that is around looking at what is the human experience of the user. So clearly, if the users could get together, they would have a stronger voice. Usually, they just are a one-off, and someone else has power over them. But if they can move upstream, if the community or the market for these services can be part of that conversation, and if there's pressure to do so, then you have power with. So that's the thinking around the distinction.
Yeah, and it is interesting how technology can empower end users in a way that they could never have been empowered before. You know, I think there was a bureaucratic mindset, you know, sort of the bureaucratic man is power is centered at the top of the pyramid, and then it filters down to the people at the bottom of the pyramid who pretty much have to do whatever the top of the pyramid says. Whereas now the internet sort of empowers everyone, you know, where the network is kind of dumb, but the endpoints are smart. And I think it's interesting to think about how we can reconceptualize some of our visions for how dispute resolution systems can work, where the end users are empowered. I have a foot in the peace tech world, and one of the mantras over there is nothing about us without us. And this whole notion that we as experts would design a system and then impose it on people that essentially never had any input in the design of the system, that's not the future. The future is the participants need to have a voice in how the system is designed, because it's going to mean that they have more ownership over it too. So that's a pretty radical reconsideration of how dispute systems design can work. It's not the experts in the room hatching a system that they then impose. So it's fascinating. I don't know if anyone else has thoughts related to that particular topic. And Ethan, Jeremy, do you have something you wanted to say?
Well, I'm just wondering about
Hi, Jeremy.
Hey, Janet. I'm just wondering, and you've heard me go on this, but when we have artificial intelligence kind of predicting people's personality traits and their likelihood of wanting to engage in certain styles of negotiation or processes, and they don't have the knowledge all the time, isn't it almost useful to let these systems try and at least come up with some hypotheses or make suggestions on process design? Because I can see a lot of people saying, I have no idea, you just tell me whatever it is, I'll do the process. So these algorithms might not be so bad. You could give me option for process design, but I do think some of these algorithms will be able to make good recommendations.
Certainly, and as we know from negotiation more broadly, a good resolution proposed prematurely will probably lose out. So the timing and the pacing of someone's choices, both in terms of process and in terms of outcome, I think is something that a human has more sensibilities about. And does a system, you know, have that capacity to pace someone? And I think it's possible. I'm not.
But even knowing who to involve in the system, who are the participants, what's the likely chemistry between these systems, how are they going to interact with one another? I think there's a lot of external information we tend not to think about that these algorithms will be able to do a decent job in predicting. And so if they have that, they'll even suggest, well, maybe in your corporation, this group, you might want to have these individuals involved rather than those individuals. I mean, it won't be comparing to exclude, but it might be making just some recommendations on what it thinks might be, you know, council, no council, is it senior management or middle level management who participate in the process? Those are things that might come up through these algorithms.
So there are two examples of that are versions of that are out there. What is the one, Colin, renttervention? Is that parking tickets?
No, that's rent. That's landlord-tenant disputes.
Landlord-tenant.
Chicago. Yeah.
So you're turning over your agency to, you know, an algorithm, essentially. I've heard of another one where they negotiate your salary for a job. And the algorithm can read the offer letter from the employer and gauge, you know, how to respond. So I think there are all versions of this that are out there. Do we want to just turn over the decision-making power to someone else because we think they can do it better?
Yeah, I mean, this is something that Jan and Ethan and Leah and I touch on extensively in the article that we're working on. This notion of, I think we often have thought about an algorithmic design for a dispute resolution process where all the participants are human, and then the fourth party is sort of administering the neutral dispute resolution system that the human participants are going to use to achieve an outcome. But what we're starting to see from a negotiation perspective, as Jan describes, is that individuals are essentially empowering software agents to negotiate on their behalf. And that's what we're seeing, for instance, with do not pay, you know, where it's like, I don't want to pay this parking ticket. You go to an agent, you give it the information, and then that agent will go off and fight the parking ticket on your behalf. Now, I think it's different than what Jan said. It's not like you have to abide by whatever they come up with. Maybe the agent comes back to you and says, hey, I got you a 50% reduction in your parking ticket. Are you willing to accept that, or do you want me to keep trying? But what we're seeing is corporations are creating these agents to like go do collections on their behalf. And it's all automated. It's all software negotiating against hundreds of thousands of debtors. And then you have individual consumers who are using these agents to go file for their unemployment benefits or appeal their parking tickets or try and, you know, prevent eviction. So it's not that the fourth party is only administering the dispute resolution process neutrally like the mediator. The mediator, may have our own agents as dispute systems designers, but the parties are going to have their own fourth parties as well. And then it may be that they're going to be engaging, you know, once they get filled up with all the information from the humans, they're going to engage in the clash and come up with a proposed resolution, and then come back to the humans and say, hey, this is the best that I could do. Do you want to accept this, or do you want to try a different channel? So Jeremy, I think you raise a very interesting point. Yeah. Ethan, Jeremy, please, do you have more you want to say on that?
I just think we are really talking about two different aspects of this. You're looking more at the help in the negotiation, where the recommendations are, how to move it forward. I was really just trying to address the concept of process design, which I think is a terribly confusing thing for participants. I think even lawyers are confused by process design, and yet people go to them for the expertise. So you have the blind leading the blind. You got so much complexity. People don't understand the consequences of the choice of process and the social impact it's going to have on relationships and everything else. So this is where I'm just suggesting that artificial intelligence might actually be, not to say it must be this way, but to kind of make recommendations. I think we're almost there with the technology. If you look at the Crystal Knows stuff, and you look at groups and the group dynamics and how they're likely to get along within the group, and it's fascinating to see the prediction ratings. And you know, I've had several situations of teams of people have had to mediate, where I've kind of after the mediation thought, okay, let me just look and see what would have told me had I done it beforehand, because I have the ethical problem of I don't want to look at it before the mediation without their consent. Colin, it goes back to what you were saying before, that, you know, don't use anything I don't know that I've provided in a way. Right. But that's exactly what this is doing. It's saying there's information about all of us, our preferences in negotiation, how we're going to behave in certain situations, what trigger words are going to make us more friendly or constantly more antisocial, trigger us in opposite ways. And so when you have these, you know, these algorithms, you've been writing how to write a first email to make a cold call good impression. That's looking at your personality in ways that you don't even know is out there. So it's fascinating when you start to think but again, I was just trying to talk about process design.
Yeah. That's fascinating. Ethan, did you have anything you wanted to weigh in on all of this?
Well, unfortunately, I got called away for about 10 minutes of the presentation, but what I sense from the last few minutes is an issue about transparency. I mean, all these systems are dependent, the AI systems, the algorithms, they're dependent upon processes that we can't understand. Although maybe I'm wrong about that. Maybe systems will be able to understand them, but at some point it's a black box, and we're relying on these systems. And I'm wondering, Jan, how much of a challenge that is, or how much of a difference that is between transparency as you're talking about it in the non-technology area and the ODR systems.
Well, I think you have thought about this, that it comes down to the whole notion of trust. What makes a process and therefore its outcomes trustworthy? And so what does the technology need to present and qualify in order to build sufficient trust that you'll use these new and innovative processes? So that trust seems like a very human element that we're trying to capture. And whose trust are we getting? Is it the bureaucracy, the institution? Is it the trust of the individual? Probably both. And over time, does trustworthiness shift? I think our children, their sense of privacy requirements are quite different than mine. I'll speak for myself. So my expectation about all my profile information online, I would prefer it not all be online, but my daughters figure that's the way it is. So the element of trust for them in terms of transparency and confidentiality is quite different than I am. And I'm wondering if it varies by culture as well. So that may be a community culture versus a more unitary culture. So thinking about what are the contextual elements that would shape the answer to that question.
Yeah, for me, I think that Ethan's question goes back to some of what Jeremy was saying too. I think right now, trust in algorithms, particularly machine learning algorithms, where we don't really understand what's happening on the inside because it's more complicated than we can comprehend. I think that trust is low. I think people are skeptical about algorithmic solutions. But over time, as we start to see the fact that these algorithms can deliver insights and capabilities that we didn't even know existed, I think trust is going to build. And eventually we're going to get to the point where even though there is a lack of transparency in some of those algorithms, we'll be able to evaluate them. And this gets to the whole question of justice. You know, what is justice? I think we're process people. So we're very focused on procedural justice. But the way these algorithms operate, we can't understand the process. It's too complicated. So we're going to have to evaluate them on the basis of outcome. And outcome-based justice is quite a bit different than process-based justice. But looking at those outcomes and realizing that they're better, they're more consistent, and they generate insights and fairness more effectively than human-powered processes is going to make our trust in those processes grow, even though we lose some transparency. So
I feel like I have a dog barking in the background. Sorry, can you hear me at all?
We can hear you, yeah.
Yes.
Thank you. I feel like that's one of our jobs as mediators, is to help parties understand the importance of the process. Because I think typically when they come, they're just outcome focused. It's just, I need the house, or I need the raise, or something. And if we can help them understand the importance of the process and feel like there is transparency and trust in the process, and that everyone had an equal voice, and they understand now why they arrived at a conclusion, that typically if they feel comfortable with that process and they understand why the algorithm gave them such an outcome, then people are completely willing to accept a different outcome than what they came in with. But it's when they feel like that process is shrouded in some mystical formula that they don't know and they're not sure if they'll accept, then they're still going to be holding on to their original anticipated outcome. So it's us helping them understand that design so that they feel comfortable with it, right? So then they're willing to accept a completely different idea than what they walked in there with.
Well, your point really raises the importance of prevention and the diagnosis up front. You know, what are we talking about? What are my choices? How do I think about this? So that goes into some of the more the pieces that Jeremy raised. So I think that what phase are we in? And when we first start, tension with our spouse, or is it when we're, way down the road that we realize there are choices and that we could make them?
Well, it makes me think of Hitchhiker's Guide to the Galaxy, where they create this computer to create the answer to life, the universe, and everything, and they wait a million years, and it says the answer is 42. And they're like, what? And they said, well, what was the question again? The parties need to know, maybe the algorithm needs to deliver not only the outcome, but it needs to provide an explanation as to why that's the appropriate outcome for the parties to go through that psychological journey. That's what Gene Sternlight said in our last webinar. There's a human psychological journey that gets you to the resolution. It's not just about a genius computer. It gives you the outcome at the end, and then you can jump over those steps. And I think that's what Claire is saying too. But I do think our norms are going to change radically as these computers become more capable, because we're just going to say, well, the computer, deep thought says this is the right outcome, so it must be. We just don't understand. Other people who haven't said anything yet, does anyone want to raise any points or questions? Kevin, please.
I'm reminded of landlord-tenant cases here in Colorado where there's a disparity in power between the landlord and the tenants typically. The law favors the landlord generally as opposed to the tenant. And one of the things I've been doing with tenants who tell me, and I've heard these words almost verbatim, you know, I can't do anything, I don't have any power here. And what I direct them to do is to prepare for the argument basically and get the details together. So if you were charged this, what's your counter to that and why would it be different, right? Many times there's just one number or a general statement of, well, we had to do this and this and this. And so the landlord, you know, the landlord just do this and put it out there and don't confer with the tenant about why this particular decision was made. It's just one and done. And so when I talk to them, I say, well, you do have power. You have power of information. Put your argument together, prepare for it, so that if you get to mediation with the landlord, you can show why you're making the request that you're making. And I'm wondering about that in a situation, in a systems design like this. It requires human intervention. I don't think it can be done strictly with an algorithm in most cases, simply because there's that fuzzy thing. However, it might be possible for the parties to put their information into a system and then produce a possible outcome, or maybe several possible outcomes, which then could be mediated, right? You could just, then the parties could accept, or the landlord might say, I accept version A. The tenant says, I'll accept version B. Okay, well now you got a basis for conversation. But this idea about power imbalance is so true, and this preparation is what I've seen as a means to modulate that power imbalance. You know, bring it closer to parity, right? If you can get parity on information, then you've got something to debate. And any mediations I've done successfully, I've always found that having some objective basis for the conversation and some objective basis for the decisions really helps people out. Yeah. So I don't know how you design that into this, but well, I do. I think you can probably design it fairly well, but you know, there's that qualitative aspect of, well, there's these set of photos, right? Well, you know, yeah, we have scanning software and so on that could look at different images and maybe make a comparison, but that's, you know, who knows? The other aspect of this, I think, is if you propose to the parties at the outset in a contract, we're going to use this system as a tool for managing our disputes, or as a starting point for managing our disputes when time comes to settle. It would, you know, this is the other thing I prompt people to do is, a lot of college students say that they just roll in and they're not thinking about anything else except getting out to meet their friends and do things, you know, outside of their apartment. My recommendation is always make sure you take photos before you start, get everything documented, and then share it with the other parties, right? So that helps, I think, downstream in these debates, these disputes. So there's some preventative measures, and then there's this power dynamic management that might be done. So I've gone on longer than I thought I would, but there you go.
Well, I think you raised some really nice examples of how, if there is a choice, I'm just gonna I'm gonna leave. I'm gonna move out because I just can't deal with it. So that's one choice. Another is that you gather some data, and there's a magic algorithm that might give you some inputs on possible outcomes. And then you choose, do I want to sit down with this other person? Do I want a mediator to help us? I mean, I think what you describe is giving the party some agency, that I can gather information, I have voice, I can say how disappointed I was, or inconvenienced I was that the stove wasn't fixed for 2 months. Whatever, you know, that information flow in just the act of speaking it, maybe with a mediator. So that's a choice. Am I going to lump it, or am I going to make some effort, invest in exploring possibilities?
I think it's also interesting what Kevin says about you know, access to that research, access to that objective information. You know, that may be, you know, information can be a power imbalance in and of itself, but technology can do a lot to redress that. I mean, if the parties come in and they say, you know, the landlord says, well, you know, I'm going to give you $200 back on your security deposit, but the algorithm says, well, we've looked at 1 million cases, and in most cases, you know, they get $600 back on their security deposit. I mean, that's a simple example, but there are ways that the fourth party can address some of that information asymmetry as well. So that's an interesting thing to think about from a dispute systems design perspective. Other thoughts, comments, questions? I think there may be, you know, we only have 8 minutes left, Jan. So I think it would be helpful to make this very practical for individual mediators, you know, who are doing online mediation. How is DSD? How are these principles? How is GASCAP? See, I'm using the acronym. How is GASCAP going to be really helpful to them? Why does it matter to know these dispute systems design principles? If you're just working directly with the parties that come in your door, do you need to think about all of these aspects, goals and feedback and sustainability, all of that?
Well, I think the lawyer, if there is one, and the mediator are both in a position of saying, is this a one-off, or are there a number of these coming down the pike? So I think just stepping back and say, is there a bigger picture here to consider? And what would the options be? I mean, I feel like that's the strength of thinking is systemically, is if, is this a one-off? Is this a broader example? So PD Villarreal, who's head of litigation for Glaxo, came up with a system for his in-house disputes and claims. I mean, he had millions and millions of litigation cases out there. And so he really tried to get his organizationally train all his lawyers and executives in basic negotiation skills, and then organized it such the early dispute planning John Landy has written about is saying is the first time something surfaces, do we want to catch it there? Or are we going to wait till it really is bloody? So I think either a lawyer or a provider, mediation provider, can ask those diagnostic questions around the case. And it may help to leverage someone who has very low power, like an employee, to know, well, gee, there may be other employees who feel this way too. So this isn't just a one-off. This has got a bigger impact organizationally. So I think, you know, trying to be practical about it is just to ask that question. Are there more of these? And can part of the settlement include a change of organizational process that is more responsive to the interests of the employees or customers or whatever?
Yeah, I worked with a software developer the guy was just a genius. And he said, good developers only have to solve a problem once. Because if you go in and you see the problem, you write a script, and then every time that problem crops up, you use the script again, and it solves the problem. So I think good dispute resolvers need to do the same thing. Every time we have a case come in, we do a mini systems design. And then it means, okay, great, now we have a system for that kind of case. I think also about these tripwire designs where, and that's what PD talked about too, if you have 10 or 20 cases that all look the same, it's the same issue over and over again, at some point you trip the tripwire, and then you have to flip it around. And it's not about the individual complainants coming in and reporting the case. It's about the respondent proactively doing an investigation to figure out everyone who is affected and then designing a system that can provide redress for everyone. So again, I think even in an individual case, we're still doing dispute systems design.
Yeah.
So other thoughts, comments, questions for Jan?
What's the name? What's the name of the book again?
Dispute system design.
Okay.
It's just descriptive.
Very descriptive. I happen to be part of a large system called the Los Angeles Superior Court. You know, it's the largest integrated court system in the world. With over 600 courtrooms and 550 judges, and it's got everything going. So we have a contract with the court to do civil mediations. The court has decided to outsource its ADR program. The problem is that there are many people who you know, like debtors, we're getting a lot of calls about credit card collection. And what they're telling us is the creditor is unwilling to negotiate.
Mm-hmm.
So one of the problems is I think the system is stacked against the debtor.
Yeah.
Because when a creditor says, and they do a sloppy serve, you know, they throw the complaint on the doorstep or they leave it with somebody not the defendant. And now the party has to go rushing into court to say, I wasn't served. And then they get served. I mean, the system is so poorly designed for people who are in trouble now. And there are going to be thousands of people like that, as well as the landlord-tenant situation, which the court is not set up to handle. And so our program is trying to address that. I'd love to consult with you about a system for handling what we expect to be thousands of cases coming out from the unlawful detainer moratorium, you know, that will be lifted. So we've got a huge problem here. We've got 60,000 people now on the streets in LA, and there are going to be another 100,000, I suspect, when the moratorium is lifted. So I think we need to develop a system that can handle a flood of cases and put some balance with the debtor and the tenant, because they're screwed. They're just screwed under the current system.
Well, I've worked on something similar with San Mateo courts and guardianship issues. And a lot of the problem is really on notice. Exactly. So that is absolutely somewhere where technology can help get a more effective notice system in place so parties can even engage their case and pursue an outcome. So I think that is a very systemic question. And then raising it up to the California Judicial Council so that it is statewide and that resources are devoted to something like that. So that is an example of just the user experience in guardianship cases was really unsatisfactory for everyone. And so how to modify that, look upstream the information flows and how technology can help.
Yeah, Jan and I, she brought me in to co-teach a class at Stanford, and then we teach together at Santa Clara. And a lot of these young lawyers, they say, well, you know, what are there going to be lawyers? Like, is my job going to exist? Like, is this going to be around in 5 or 10 or 20 years? And I say, well, you know, a lot of those jobs are going to go away, but I think more people are going to be working in the legal sector than ever before. Just like fintech, a lot of those jobs went away in finance, but more people are working in finance than ever before. And people say, well, what are the jobs? What are they going to be doing? And my answer is this. This is what all of them are going to be doing. They're going to be doing dispute systems design. We are going to have to build thousands upon thousands of new dispute systems and manage those systems and ensure that they are delivering justice. And the concepts and the questions that Jan raises, those are the skills that we need to build the next justice system. And that's why, and there's going to be more people doing that work. It's going to be coding. It's going to be all in ODR. I think they're going to be writing software to do it. But okay, and I could go on about that. Jan, please, what are your last thoughts?
Well, my closing thoughts. Well, I hope some of the concepts are resonating with you and that you can use them. I really think that once we name what we're trying to accomplish and inform a concept, I mean, what is your goal as a mediator, as a professional, as a citizen, and what are all the places where you interface with people and disputes, and what are the choices and how can you facilitate an expansion including ODR?
Jan, thank you so much. This was really wonderful. So much to think about. I know we have a whole tome that we could barely dip into some of these topics, but it was a great taste. So can everyone please give Jan a virtual round of applause? You can do this one too.
Thank you very much. Thank
you so much.
Good day.
And Jan is a resource if anyone wants to ask any further questions or follow up with her. But thank you so much, everyone, for joining. Stay tuned for more news about Cyber Week coming soon and our next online webinar. And keep up the good work.
Okay.
And with that, we'll release you to the rest of your day. Okay. Take care, everyone. Stay healthy.
Bye, Dan.
Bye. Bye, Latia.
Bye. Bye.